empire. Numbers don't lie, they testify. Thomas in the lab, books open, case law. Reading every line like a judge on the last call. Turned credit acceptance to a conquest. Took a contract apart, made them confess. Consumer finance, that's chess, not checkers. Built a blueprint, now we training whole sectors. From the payment plans to the charge-off sheets. He can map out the money like Manhattan streets. Understand risk, yield, real valuation. Break a deal down, show the hidden obligation. He don't chase clout, he chases precision. Every decimal in place like a surgeon's incision. Supreme elite, we got receipts. Stamped in the ledgers and the court transcripts. You see defeat, we see a breach. Thomas turned pressure and the long-term wins. Dark in the hook, but the numbers still glow. Empire built slow while the cash flow grows. Supreme elite, we got receipts. Every page proof that the We are back with part 2. It's early. Got a lot of things to do today, so I wanted to actually finish part 2 from yesterday. And
you're rocking with the best. You're rocking with the best.
We are back in the building. So yesterday, if you didn't catch it yesterday, you can catch the live stream on the New Culture Empire. Not today, the one from yesterday, the latest one. In that live stream, we covered the realities of the shift in the court doctrines, the realities of the shift in how courts are making rulings as it relates to consumer transactions and the consumer laws, and how over the past 30 years, court doctrines have shaped the course and fate of litigation, and mainly pro se litigations. Now, we're going to tie that off from last night into an actual motion that I crafted myself. But before we get there, I just want to go over the summary of last night. I just want to go over a quick summary, and I'm going to start with the final. Let me see. I could start right here. The final summary. I'm going to start with the summary to refresh your memory. I know people go to sleep. I know people got a lot of things going on, whatever. So I'm going to refresh the memory from last night. So this is where we left off. We actually completed the whole thing. I'm just going to go over it to refresh your memory so we can, get on to the new things. We are streaming live on Facebook, YouTube, and TikTok. So shout out to all y'all that's here this morning. Something new. I really don't stream this early, but let's go. So picking up from last night before we get into the other part 2. A recurring piece of advice given to pro se litigants is to, quote, read the rules, end quote. The federal rules of civil procedure, the federal rules of evidence, the local rules of the district. That advice is necessary. It is not sufficient. And treating it as sufficient is one of the most common reasons a well-founded position loses. Now, I'm going to be 100% honest. I see quite a few teachers kind of adhering to my guidance, which is cool. I mean, anybody can learn from anybody. But I start to see that a lot of what I'm saying is starting to sink in with a lot of teachers as well. It's kind of what I planned and I orchestrated before I started this. I'm starting to see them parroting some of my, talking points and pushing the message out further, uh, so it can at least start a shift in the way pro se litigants think about their cases. So shout out to the teachers is actually, taking the movement and you know, and spreading it and adding, pushing it to their own crowds, to their own people. Shout out to y'all and know that y'all been paying attention and y'all trying to get on board as well. Knowing that the Federal Rule of Civil Procedure 56 governs summary judgment, or that the Federal Rule of Evidence 803 subsection 6 governs business records, it tells a court nothing about how that rule applies to the specific facts in front of it. Meaning, just because you cite a rule in your briefs, that doesn't actually prove your case. Same thing applies to just because you're citing case law, it doesn't mean you prove the case. Rule 7B1 requires that a motion state with particularity the grounds for seeking relief. Particularity, not citation. A motion of brief that recites a rule number and stops has not yet made an argument. It has identified the subject the argument needs to be about. So when you see people online citing that Phyllis LaSalle versus Phyllis Horace versus LaSalle Bank, even though it's not good law in Alabama and it's outdated and nobody has won by citing that case in the last 15 years, regardless of that fact. Or when you see people cite Galaski, which has been overturned by Ivania and Yasserel. When you see many people cite cases, they're not taking into account that the courts are not analyzing that case based on its final order. The courts are most definitely are going to use the distinction. They're going to narrow the scope of that case only to the specific facts and elements of your case. So if your facts and elements and you're connecting the rules, procedure, and the case law to your specific facts of your case, the courts is going to make that narrow distinction. Well, defendant cited Johnson versus Federal Home Loan Bank. However, in the Federal Home Loan Bank, that case was dealing with such and such. Defendant has now argued or alleged that any actions taken by the banks would, be in line with that case. Therefore, we decide not to consider that case as part of defendant's merits. Yeah. That's what case law comes down to. And that's one of the things that I've learned over the years. It's not just about citing the case. So shout out to the teachers, because y'all got to remember, just because you haven't seen my presence on here doesn't mean I wasn't around watching. This is kind of one of the first things that I've seen that's tackled. Remember, I was watching this space for a couple years. And then last year, I kind of started my page. So by the time y'all see me like more presence online, I've already known what people were talking about and what they was not talking about. So regardless of whether you switching your tone and getting on board today, I mean, that's just the most important part anyway. But once you turn over a new leaf and start to use the set you influence, you got to stay on a tight, narrow path, because the only way there's going to be a change in the mindset is if there's consistency in one's position. Teachers, you can't be effective if every month you're changing your position. Now, caveat, I understand once new information becomes available that everyone has the right to change once more information comes about. But this is why everybody should take their time before moving. So you won't have to keep worrying about going back and redoing this and redoing that, redoing that. This is the reason why there's so many amended complaints being filed. First amended complaint, second amended complaint, third amended complaint. How many pro se litigants do we see day in, day out that had to file a second or third amended complaint? That is, court is not the time where you start to experiment. It's not that time. They're not looking at it the way you're looking at it. They are looking at you. Okay, you decide to represent yourself. Okay, you know the court rules. You know the court procedures. You know the distinctions. You know the rules of evidence. You know this just like you went to law school. That the only leeway the courts is going to give you in the formatting of your complaint. And if you're an open court, they may help you with cross a little bit and overrule some objections from the other side that they really shouldn't, and give you an opportunity to either re-answer the question or rephrase. But when it comes to procedure and presenting your argument, we got to stop acting like the judge is going to fill in the blanks for us. Now, a motion or brief that cites a rule number and stops has not yet made an argument. It has identified the subject the argument needs to be about. Professional advocacy, the difference between citing law and arguing it. And this is where I need the teachers. I need y'all to start parroting what I'm saying. Y'all can't continue to keep telling your students that all you got to do is just read this and read that. No, you got to go further than reading it. You got to get to its application. How does this align with the relief we want the judge to give us? How the facts of this case, how to identify facts and elements of the case and tie the elements back to the court doctrines, back to the rules, procedures, and substantive case law. Because I've been seeing it for 2 years. They post statutes and say, all right, statute 1692. Look, it says this. But they're leaving out the fact that when it gets in court, you got to understand that just because you read a statute on its face does not necessarily guarantee that you have interpreted the statute. The statute is not going to provide a specific 100% elements to the case. Your facts and your elements of your causes of actions needs to be in line with the intent of the statute. Courts are not going to just today, I'm talking about today, how courts operate today. They're not just going to grant you relief just because you pointed out a technical violation of the statute. If you did not also show real world harm and injury. I know it's not fair. I know the goalpost keeps moving, but this is the reality of court. You can always expect the goalpost to move. Generally has 4 components, and all 4 expected regardless of whether the party is represented. The rule or standard that governs. It's the first one, right? This is the first one. You have to identify and fully understand the rule or standard that governs, stated precisely, including any elements or factors it requires. So just because you cite a 1692 statute, you have to be aware of its underlying elements. And you have to be aware if your facts or circumstances align with the underlying elements. Just citing it is not good anymore. They've changed that through court doctrines. I said it last night. Courts change laws through court doctrines. It is a loophole, meaning they don't even have to touch the actual wording in the statute to change the statute, because laws are indirectly changed by courts through interpretation. And now, unless it makes it all the way up to the Supreme Court, you're pretty much stuck with what the courts say. The second one, the specific facts in the case tied to each element of that standard, not the facts in general, but the facts that satisfy or defeat each requirement the rule imposes. This is the most dangerous part right here, because on social media, the way they frame your elements, what you can do, you're the lender, your signature create the credit, you're the grantor, you're the beneficiary of the trust, you're entitled to the proceeds, the coupon. Prime example, if you was getting sued in court and they said you for non-payment, but you said, no, I've made payments, you got to look at, the courts are not going to look at the definition of payment from a esoteric, out there in Jupiter's way. They're not going to play the semantics game. The courts are going to look at the everyday, normal meaning of what payment means. Every day, every normal person that can understand, when you go into 7-Eleven, you're either giving them cash or credit. Credit that is linked to some type of financial institution in which you have access to the funds. So you got to look at it. How would this play out, this coupon method, if I had to explain it to the judge? You got to forget what the teachers are saying. Forget what the group is saying. Forget what you want to be true. How can you explain that they receive real and lawful legal tender? How can you explain it? Because if you can't explain that to the judge, you can't explain that to the IRS. So if you cannot explain it to the IRS, that real money in which you receive credit for that payment, or you were supposed to receive credit, if you could show the IRS that you, if you could show the IRS that real money, real taxes were taken out and covered over, real cash money, not the way withholding. The withholding has to have real money attached to it. Not, well, they forgot to report, or they didn't do. No, you can't prove what they didn't do. That's not what they're looking at. And if you can't prove it, your account is going to be reversed. And they don't always come back in a year. They don't always come back in the following year. They come back long after the money has already been spent. Want to know why? Because there's quite a few people who just suffered the same fate last week. I'll be highlighting it in the upcoming weeks. Oh, yeah. Fresh off the press. Got the money erroneously. The IRS asked them for the money back. They kept sending in documents, and you know how they tell you to do, how to keep the money? The IRS said, we had enough of y'all. This is your last warning. And then the government came and indicted them. And the easiest thing that they indicted them, wire fraud and mail fraud. Because you mailed the fictitious instruments and you used the postal service to facilitate that fictitious instruments. That is one of the easiest federal crimes that they can prove. And since you transferred the money to another account, that's another easy thing to prove, wire fraud. Every time you get a fake check, an erroneous check from the government, and you mailed off your original instrument, you broke the law. If you transfer that money to another account, you just broke the law, because now they can prove intent. And your social media class, your group, you can't, that's not a viable defense. So basically, to wrap it up, to get back to the live, basically what I'm saying is, Many people are doing processes online, taking advice without looking at the fact that if I had to explain this in front of a judge, would I be able to satisfy all the elements under the law? And this is where a lot of people will fall apart at. Number two, the specific facts of the case tied to each element of that standard. Not the facts in general, but the facts that satisfy or defeat each requirement or the rule imposes. If you can't bring your claim and park it in front of a courtroom, that does not mean try it the administrative way so you don't have to explain it in court. Because if you can't explain it in court, you can't explain it in any other facet. Third, the reasoning that connects the two. Why these facts under this standard produce this result, including engagement with the language courts have used in applying the rule before. The reasoning connecting the two. So what is your reasoning for the statute or the rule that governs and the specific facts of your case? See, these are questions that you already have to have answered before you put pen on paper. And this is the reason why many people are being faced with a motion to dismiss off the break. 4, the conclusion the court is being asked to reach, stated as a request for a specific ruling, not merely a description of the law. So many people, this is the norm. They'll say that they'll quote a statute or rule or regulation or the Constitution. And then as soon as they quote the statute, they'll say the defendants broke that or the plaintiffs broke that. And then they'll conclude that they made some type of violation in their complaints. This is, if you were a lawyer doing that, you may lose your license. You may be sanctioned. The court is going to look at you like, what the hell are you doing? This structure is taught for first-year law students. Issues as IRAC. This is what they teach law schools. IRAC, IRAC. That's what they call it, IRAC. The issues, rules, application, conclusion. Part of this newsletter, of course, all the sources I cited, but it's actually comprised of multiple law firms and law schools, Harvard, Yale. And parts of it came directly from a handbook that lawyer studied. This is what they're being taught. First year in law school, they're being taught IRAC. They're not moving off it. Rules, procedure, rules, procedure, rules, procedure, rules, procedure. Issue, rule, application, conclusion. Application, conclusion, issue, rule. Rule, conclusion, application, issue. And all those, right, they're not moving off that in their first year law school. Precisely because the application step is where cases are actually won or lost in the applying what you're saying to your case. If you did not adequately apply the rules, its application, and the specific facts to your case, the chance of you having to file a second or third or fourth amended complaint is right around 97, 98%. Most likely, you're going to have to refile again. The case is not going to move off. See, I'm not, if you want to sit there and say, well, you got to start somewhere and learn, if you want to sit there, if that's your mindset, cool. But I'm not really talking to people who don't want to push themselves to be elite at this, meaning you're getting it right the first time you filed a lawsuit. If you feel like you got to, well, I'll just retry again and try this argument now, pretty much this is what they're not going to tell you. You get one shot to impress the judge. If you got to file a amended complaint, your credibility has already been shot by 50%. So that means you have to do everything the second time that you didn't do the first time. And if you didn't understand it the first time, you ain't going to understand it the second time. Because you think you just got to change your argument. You think you just got to change a few things around what they did or word it differently. No. If you didn't understand IRAC the first time, you're not going to understand IRAC in your second amended complaint. Prime example, equal footing. Keeps filing brand new lawsuits. Why? He doesn't understand IRAC. Precedent is argued by analogy, not recited. Citing a favorable case is the same problem in a different form. A court does not follow a prior decision because the case exists. It follows a prior decision because the reasoning in that case applies to the case now before it. That requires showing how the facts of the cited case resembles the facts at hand, or when opposing authority is cited against a party, showing how the facts differ enough that the same result should not follow. Every time you cite a case, the other side is going to attack that case if the elements don't line up. And that doesn't mean you object just because they give their side. That's another thing I got to talk to people about. How to object without objecting with feelings and emotion because you don't like what someone's saying on the other side. And this is everything. This is why I tell people, man, we got to start taking pro se seriously. We're not taking it seriously. We're not taking this stuff seriously enough. We're not putting the work in. We're trying to cut corners. You got to stop trying to cut corners. You got to recognize where you're at. If you know you're not already there, stop trying to force yourself to be where you're not. And court is the last place to learn this stuff when your property and stuff is on the line. And one of the major things is, well, what do? We can't just sit down and let them do it. Okay, let's just walk it back for a second. Go all the way back to the inception. What part of that do you control? What part of the obligation is squarely within your control? Meaning, if you don't live up to this agreement, what can happen? You can 100% prevent that. Besides catastrophic events that's taken place, we all know the exceptions, but the exceptions represents less than 5% of these spaces. A hurricane come through, or the breadwinner got cancer, or lost their job, got their leg amputated. The extreme events, I'm not talking about that. Because the data is, that's only about 5% of the spaces. The other 95% of the spaces comes down to the borrower just stop paying. We can't stop. We cannot ignore you stop paying. That is what got you in this space in the first place. And just because you uncovered, and I use this term very loosely, fraud against them, that doesn't give you the right to stop paying. Because now you have breached the contract. Because there is no written agreement saying if you uncover fraud, you don't have to pay us anymore. That's why if there was fraud on their end, you should have brought the lawsuit first. Courts have a hard time hearing your activating event that started this whole thing was non-payment, and then your response to it is fraud, or your response is show me the wet ink signature, or your response is you never loan me anything, or your response is I'm the real creditor. These are arguments that if it was so true, they wouldn't have taken you into court for non-payment anyway. There just would have been a set off of mutual obligations, because if they owed you as the creditor but you owe them under the note, then they wouldn't take you to court, and you would have made sure that agreement was in writing. How do you remain so silent on something that is so important as you being the real creditor? Why would you remain silent to that at closing, during the negotiation stage, during the time you're signing the note? Why would you remain silent and then come back later and says, hey, I'm the creditor now? Those things are in writing. Those relationships are established. Why would, and that's how the court's like, hold on, if you're the creditor, why you wait 2 years? And the answer can't be, I only found out when I was in default. That answer doesn't work. You can't be, I didn't know then. No, that's not the answer. Remember, competence gets compensated in the United States of America. Ignorance, it costs to be ignorant. There's been plenty of things it cost me because I didn't understand what's going on. That don't mean just because I understand now, I can go back and change the hands of times. So it's better to understand the realities of court and start coming with legal viable claims under what the law recognizes, not what you think it is, than trying to raise arguments when everybody knows the real truth behind those arguments. The courts see through those I really don't want to pay arguments, masked as fraud or concealment or breach, or I'm the creditor, or you didn't loan me nothing. You only loan me credit. You're supposed to loan me money. Because you didn't raise that objection to when you purchased the house that you got it on credit rather than real money. See what I'm saying? That's what they're all looking at. Well, you didn't say nothing when you got the house. What's the problem with it now? So this is why the judges keep coming with these rulings saying the borrowers just don't want to pay. The borrowers took out a loan that they just don't want to pay back. At no point throughout the term did they raise these objections. Now that they're in default, now they raise the objections for the first time. That's literally from a court case from 2007. At no point, and another one, 2016 as well. At no point did they raise the objections. They made payments on the account. At no point did they raise these claims. Now that they're in default, they raise these claims for the first time. That's in the actual judge order, in his opinion, in its ruling. It's not me. Remember, I know they don't like to hear from me. Now, this requires showing how the facts of the cited case resembles the facts at hand. Oh, we already did that part. Courts have said this directly. This is not merely practice advice. It reflects standards courts apply when deciding whether an argument has been preserved at all. The Seventh Circuit put it memorably. A court is not obliged to research and construct the legal arguments open to parties, meaning they're not hidden. They're all within case law, substantive research, investigative research, all that, especially when they enjoy the benefit of representation, aka you should have just got a lawyer then. We're not going to reward you for not exercising your right to get a lawyer who's licensed in these things, who are trained in these things, who understands law way better than you. I don't know why many pro se litigants in these spaces think they understand law better than attorneys. You don't. Let's just be honest. You don't. But because everything in this space is always tied back to the redemption patriot movement, that many people has that foundation and a sprinkle of it in their arguments, regardless if they never say the word, regardless if they stay away from the phrases. I can tell that influence is in there. When A lot of lawsuits are overly relying on constitutional violations. That is a hallmark of a sovereign citizen argument, regardless if you believe you're one or not. And more bluntly, judges are not like pigs hunting for truffles buried in briefs. If you think the judge is going to cipher through your 85 pages of documents you attached and try to figure out what you're trying to say through those 85 pages, you have been misinformed. If they told you all you got to do is attach an SEC form, file into it, and that's it, you have been misinformed. Courts across the country, this is why this newsletter is so important. It's not just tackling one state or this state or my state. This is the national consensus. This report comprised of research of data of court rulings across the country. This is why in this newsletter, you see how the courts started shifting their rulings over the last 30 years. This report covers in 8 pages the shifts over the last 30 years of court. They're not teaching you to study the courts in its entirety all across the world, to stay up with the movements and the shifting in the rulings, because a ruling in one state may very well affect the ruling in another state. Not to say that you could cite case law from another state if you're in a different state, but judges look to what other courts are ruling. They're looking. Courts have applied the same principle to hold that undeveloped, conclusory, or perfunctory arguments, including a bare citation to a rule or statute without supporting analysis, are treated as forfeited and are not considered on their merits. The sad part is that's what a lot of pro se arguments are comprised of. Conclusory, undeveloped arguments, or perfunctory arguments. And they just cite the rule or statute that they violated without even explaining the elements behind the violation, the actual specific facts of the case. It's just, legal conclusions is the biggest Achilles heel in these spaces. Y'all, you got to stop making legal conclusions in your court argument. I know it's hard not to do. Y'all always want to tell what they violated. That's not your job to tell the courts what they violated. It's the court's job to determine whether their statute's been violated. The Supreme Court, remember y'all Supreme Court legal beagles? This is what they're saying. So you can't get mad at me. This is what they're saying. I thought y'all don't even follow Supreme Court law. Y'all look at Supreme Court as your guiding light, your best friend. So that's what they're saying. This is what you can't do. You can't make legal conclusions. And it's in every pro se motion I read. A legal conclusion. It's in every single one I read. It's in every single one. And if you don't know what a legal conclusion is, that's a big problem. If you're just hearing this term for the first time, that is a major problem, especially you've been filing things in court, because you can't even identify whether you're making one or not. And this is where experience comes in at. This is where experience comes in at. This is where experience, when you lack the experience of being inside of courtrooms, you're not going to see things that you need to see. They're not going to be evident to you. And this is a natural part of life. The more you do it, the more you understand it, the more you'll be able to see further down the road. Stop trying to force yourself to see at the end of the race line when you know you're still at the beginning. It's okay. You don't start off just because you're doing it yourself. You can't think that you're already on that level. There are plenty of people, if I could have just told without them getting upset, and that's another thing. Personal feelings, emotions is another Achilles heel in these spaces in their emotions. I see too many emotionally filed lawsuits. Everything is just filed because you don't like what they just did. That doesn't work in court. Self-represented litigants do receive real accommodations. Pro se pleadings are held to less stringent standards and are construed liberally in their favor on matters of form. but that leniency has consistently been described by courts as applying to pleading formalities, meaning you got the facts right, you got the elements right, you're just not putting it in the proper legal technical term as attorneys. They're not going to punish you for that. They're going to construe it like you put it in the form, as long as everything else is right. But that's just the pleading formalities. That has nothing to do with your arguments. That's nothing to do with you making, citing the rules and standards and applying it to specific facts. It's just how you go about wording it. Not as an exemption from the underlying legal work. As the Supreme Court has put it, courts have never suggested that procedural rules in ordinary civil litigation should be interpreted so as to excuse mistakes by those who proceed without counsel. This is from the Supreme Court, footnote 23. A pro se citation to a rule is read charitably as to its form, how you're wording it. It is not, on that basis alone, treated as a developed argument. And trust me, I'm way more nicer than the people I came up under. They'd have been, you thought I'm brought and direct. They would have sent you something back, put that shit in the trash. Now, you need to be all, and even if you spent weeks on it, they'd have came, man, put that shit in the trash. You ain't getting nothing. You ain't even, and they're gonna be like, you violated this, you ain't do this, you ain't do. They'd come back with a laundry list of things you didn't have in your complaint. But you think since you worked 3 weeks on it, compiled, did all that typing, and you be like, damn, I still ain't, man, it would have been discouraging to a lot of people. The rule tells the court what question to answer. Only the argument tells the court how to answer it and why the answer should favor you. So as we close, this issue traces a single thread from the courtroom door to the argument that has to be made once records are inside it. Florida's Jackson decision brought the state in line with the national business record standard already used in federal court in most other jurisdictions. Records come in through a custodian who understands the system, not one who personally witnessed each entry. That same reasoning appears nationally in 3 forms. The Federal Rule 803-6 standard. See, this is what they did. The standard, each state has their own version of the Rule 803 subsection 6. But when they made rulings on the interpretation of the rule, they effectively altered the rule. The same rule, 803, years ago, they needed to know the software system. They needed to know the data entry. They needed to know how the system was pretty much damn near built. One rule that spread like wildfire across the other circuits. Now, they don't need to know that. They don't need to personally witness each entry. They just got to understand the system. This is the threshold. Hey, John Smith, who you employed for? I'm employed for Lakeview. Are these Lakeview documents? Yes. The originator on Lakeview's internal system? Yes. Are they relied on in the ordinary course of business? Yes. Do you understand how these systems are integrated and used? Yes. Your Honor, I would like to move this Exhibit A. Exhibit A. Do you have any objections? Oh, I object. He didn't know how the entries were made. He didn't know how the data was put together. Okay. Objection overruled. Admitting Exhibit A into evidence. That's all it took for rulings for the courts just to say that. That's it. That's it. The threshold is so low for them to get it. So you don't object to the business records being entered. You're actually going to see coming up a better way to raise those arguments. Then you got the adoption doctrine used in New York, New Jersey, and Ohio for records inherited from a prior servicer. You notice how these are doctrines and not statutory changes to the rules or the laws by the state legislators. Because as I said yesterday, courts use doctrines, aka rulings, to change the rules without touching the actual wording. And no, it's not illegal, because court rules, statutes, case law is all matter of interpretation. And the inherent reliability standard applied to regulated financial institutions in states like Texas and Illinois. Admissibility is not accuracy. Once records are in evidence, the task shifts to the party challenging them to show from the, this is what I mean right here, from the servicer's own numbers that the records are wrong, incomplete, or internally inconsistent. This is why I have the ledger, the hidden numbers. Get your real numbers read. You can't today just trying to attack the records just to attack them. No, you have to show inconsistencies, and the inconsistencies has to be from their side. Precedence itself is not fixed. Favorable rulings from 2008 to 2012 foreclosure crisis, favorable rulings from the 2008 to 2012 foreclosure crisis were followed by a decade of standing decisions, Spokio, Abdutsky, TransUnion versus Ramirez, that narrowed the paths available to consumer plaintiffs, even as some relief arrived through other doctrines and other branches of government. Ask yourself, how many of you have won in a foreclosure, in a mortgage, based on raising a securitization argument in the last 10 years? I mean, have you seen it? No, I don't care about what people said they did. I'm talking about black and white. Have you seen it? None of the above does any work by itself. A rule, doctrine, or favorable case is the starting point of an argument. It's not the argument. And that's the point when I'm trying to get people online to see. You think that just by citing a case, a rule, or a statute, that's the argument itself. It's not. The party that only cites has left the court to decide the case unassisted, and a court left to do that work has no obligation to do it in that party's favor. Good God Almighty.
You're rocking with the best.
It said, isn't the issue more about making legal conclusions without supporting facts? Well, making an assertion without the supporting facts is a legal conclusion. Without a factual allegation. Just saying that they violated a statute is a legal conclusion. Now you got to understand, what were the elements of the statute that they had to violate, that caused the violation? What are the elements? What does the statute say what makes an element? What does the statute say? Then what is your specific facts? Then what is case law that in a prior case, those underlying facts align to yours? It sounds so easy. Oh, okay, that's easy to track. I can start doing that. The problem is many people online think they're statutory violations when they're really not. That's the issue. They think that they violated something that they did not violate under the law. That's the problem. That's the problem. They think it's a violation when it's really not a violation. They miscite statutes. They'll cite statutes that don't even apply to servicers. They'll cite things that has nothing to do with what's going on. That's the problem. What you think is a violation, 9 times out of 10 in this spaces, are not violations under the law. It's a violation under your beliefs and feelings because you don't like what they did. That doesn't mean it's not it's a violation under the law. That's the difference. A violation is not a violation because you think it is. Now, let's get into the main event. And as always, if you are not already in Set U, Class 7 coming shortly, you need to take this opportunity.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume, war stories in the fine lines.
Don't miss out on this opportunity to litigate like a seasoned professional.
shit. If you're only, my bad, y'all. Damn. I'm gonna have to okay, so YouTube, what I'm gonna do is I gotta record it on TikTok and Facebook. I gotta record it on TikTok and Facebook. So I'm gonna go back and I'm gonna download the audio from TikTok, Facebook, and I'm gonna line up the motion to the audio, so you'll be able to see it from there. So I'm making them pull their private agreements out with this bill. See, this goes into the hearsay within the hearsay, because now they got the sources of these bills, they try to put it all in one. So now I'm just stripping down the source of this. This is a different one. This didn't come from you. This is what you're billing back to them. This is what you incurred to them. You incurred this bill to them. Now the sources of all these, because all these are not just coming from your own Loan Depot. We know where it really came from. The Florida Supreme Court applies that requirement literally. When one hearsay assertion is transmitted through another, each level must independently qualify for an exception before the combined statement may be received for its truth. See what I'm doing now? I'm taking all those different agreements that they're trying to combine them into one and throwing the Supreme Court standing right in front of their face. Now, it would have been 1,000 times better if I just could have attached their own agreements and sent it in, but I can't do that to them. Because now they're going to hit the confidentiality. You ain't supposed to have this, yada, yada. They're going to get it stricken. The second district applied that principle directly in a residential foreclosure in Roche versus National Bank, applying the Guskiminski hearsay within hearsay standard. There, the servant, you notice how now when I go back to substantiating the case law with the facts and the elements of that case, you notice how everything I'm telling y'all, everything I say, you notice how I don't just talk it. I can always show you evidence of me doing it. There, the servicer sought to prove a material fact through its own letter log, but the information recorded in the log had originated with a third-party mailing vendor. The court held that a statement situated inside another hearsay statement requires an exception at both levels and rejected the proposition that information becomes admissible simply because the servicer later records it in its own system. See also Rivera versus Bank of New York Mellon. Hearsay information does not become admissible merely because it is recorded in the regular course of business. Defendants reiterate the famous quote from Rivera. Defendants reiterate the famous quotes from Rivera means I didn't just type in a chat and say, find me cases. It means I had to actually read these cases to find the elements and facts to line up with theirs.
You're rocking with the best.
You can't cut corners in court. Get lazy and try to cut corners and try to chat your way through statute. Cut corners in court. They're going to exploit it. And you better make sure every case law you cite is accurate, real, and authoritative. Don't get caught citing a case that don't exist. You lost your case right there. It's been quite a few pro se litigants that sent me their motions and had cases on there that had nothing to do with the facts at hand. Actually, that happens roughly about 50% of the time. They had a case that was talking about some malpractice insurance shit. Nothing to do with nothing. And they cited it as a foreclosure case. I said, damn, AI done fucked you over. Defendants reiterate the framers' quote from Rivera. Hearsay information does not become admissible merely because it has been recorded in the regular course of business. This is the famous quote that a lot of defense attorneys in Florida uses. This is one of the famous quotes they use in trial, in closing. Yeah, this is what they use. And I'm telling my client, when it's her time to talk, that's part of the objective. Read this famous quote. Because every attorney, every judge knows that quote. That rule does not require plaintiff to call the individual who personally created every underlying record, nor do defendants contend otherwise. You see how I'm making the distinction before I allow the judge to make the distinction? You see how I'm saying, hold on, Your Honor, we're not asking them to do this. You notice how before the judge assumes that that's what you're trying to get them to do? Because if you leave it to the judge to interpret what you're trying to say, there's no obligation that they got to interpret it in your favor. Under Jackson versus Household Finance, a qualified witness may establish the section 90-8036 predicate by testifying to the statutory foundational elements. The witness need not have personally made the record or explained the internal mechanics of the business software. Once those elements are established, the record is admissible under 90-8036 unless opponent establishes untrustworthiness. I keep going back to the top standard. That's the precedents in that state. You notice I keep lining everything I'm talking about, the facts to the precedent. Nor do defendants disregard the related line of cases permitting one business to rely upon records obtained from another, where a business takes custody of another. Where a business takes custody of another entity's records, integrates them into its own records, relies upon them in its ordinary operations, and the circumstances establish their trustworthiness, Florida courts may treat the incorporated records as part of the receiving business's own business record. See Bank of New York versus Callaway, Deutsche Bank versus DeBrito. And what a masterful way that I use these opposing cases to draw the distinction that narrows our cases, this proves our point. Let me see if I can find let me see. So, what is it? What is that? Let me see. Hold on. Let me see if I can pull it up. So I said, hold on, let me see. Damn. So I said, this is how, so I ran it through my patent pending litigation model. He said, you are entirely correct. And that is a highly sophisticated legal distinction. Looking at it through the specific lens that Brito and its predecessor, Nation Star Mortgage versus Baroni, as well as Bank of New York versus Callaway, are absolute vital weapons for a defendant. By citing the Brito or Callaway, you are strategically telling the judge, Your Honor, the defense is not being unreasonable. We fully acknowledge that the law allows Bank B to adopt Bank A's records, but only if they strictly meet the heavy burden of proof laid out right here in DeBrito and Callaway. That's why I put it there. That doctrine, however, requires a foundation for the incorporation and reliance. It is not a rule that every assertion supplied by an outside vendor automatically becomes admissible once entered into a servicer's computer system. See Roche. Likewise, where an entry is derived from a property preservation invoice, inspection charge, title company invoice, tax-related charge, attorney invoice, or another outside source, plaintiff may establish admissibility through any method permitted by the evidence code, including a proper business record foundation showing adoption, integration, reliance, and trustworthiness. What plaintiff may not do is use admissions of its own account history under Section 98036 as an automatic evidentiary bridge, establishing the truth of every independent assertion supplied by a third party. Basically, just because you slap all these different charges, invoice, and bills and slap it under your own statement history, we're going to break it back apart. Sections 98036 and 98005 require the court to distinguish between those propositions. That's the key part right there, making the distinction. Accordingly, defendants request a ruling that to the extent any corporate advance entry is offered for the truth of an assertion originating with a third party, I keep hitting him. See, that's the undertone. Well, I keep saying originate with a third party, because I'm making them go into the clouds. I'm pulling the corporate finance and those private agreements back out the clouds. Plaintiff must establish an applicable hearsay exception for that assertion before the court relies upon it in determining the amount due. Defendants do not seek categorical exclusion of plaintiff's account history or require testimony from every vendor. Rather, defendants seek only application of sections 98036 and 98005 to the particular purpose for which each disputed entry is offered, with the admissibility determination made before the challenged third-party assertion is used as substantive proof of the amount recoverable in the foreclosure judgment. Ground 3, the redacted account identifier fields must be addressed before the account history is received as proof of the amount due. Plaintiff offers its account history as a business record reflecting the transactions, advances, charges, and balances from which the amount allegedly due is calculated. The report, however, was filed with portions of its identifying header information obscured. Among the redacted information are the value appearing in the header immediately following account history, and that was blocked, and the field designated investor account number. Those redactions appear in the same record plaintiff seeks to use as substantive proof of the debt calculation. The issue is not that redaction standing alone renders a business record inadmissible. It does not. The issue is whether plaintiff can establish that the document offered is what plaintiff represents it to be, and whether the omitted portions bear upon the identity source, account relationship, or context necessary to evaluate the record plaintiff asks the court to rely upon. Section 90.91, Florida statutes. Now, you see the sequence. It's always going to go to the governing rule, standard. It's going to go to the specific facts. Then it's going to go to the connection of the two back to the one. It's always going to go back to the reasoning to connect the two. Requires authentication or identification as a condition precedent to admissibility, and requires evidence sufficient to support a finding that the exhibit is what its proponent claims. The business record exception separately requires the predicate established by Section 98036, including the statutory inquiry into circumstances demonstrating a lack of trustworthiness, where portions of the very record offered to prove the amount due conceal fields potentially bearing upon whose account is being reported, the identity of the servicing or other investor relationship, or the origin and context of the reported information. Defendants are entitled to test those matters before the exhibit is received for its substantive truth. Plaintiff's own supplement Exhibit 5 makes that inquiry concrete rather than speculative. That filing identifies the subject loan as investor type GNMA and identifies investor number G13. Defendants do not contend that those designations themselves determine ownership, standing, or the amount due, nor do defendants ask the court to infer the contents of the redacted fields merely from the GNMA designation. The defendants narrow this point. Plaintiff itself has placed investor-related information concerning this loan into the record while simultaneously obscuring account identification fields appearing on another record offered to establish the amount due. Sometimes less is more in court. Sometimes just narrowing your point is better. Before the latter document is admitted for that purpose, plaintiffs should identify what categories of information were removed and establish that the redactions do not conceal information material to identify source, interpretation, or reliability of the account history. The same results follows from Florida's rule of completeness. See, taking the redaction and adding another rule and standard to it. The same result follows from Florida's rule of completeness. Section 9108-subsection 1 provides that when a party introduces a writing or a portion of a writing, the adverse party may require contemporaneous introduction of another portion that, in fairness, ought to be considered with it. The Florida Supreme Court has explained that the statute applies when the writing, now I'm getting to the interpretation of the statute. Remember, it's never my interpretation. My interpretation don't matter. My interpretation is what they consistently interpreted. That's how. What's your interpretation of this? What have the courts consistently held? Well, they've all said this. All right, that's my interpretation. Well, it's not. Hey, I don't give a damn what you hear online. My interpretations is what they consistently interpret. That's it. Because my interpretation don't mean nothing if it's not in line with how they interpret it. So my interpretation is how they interpret it. It just cuts all this extra mumbo jumbo garbage out. And of course, if you haven't done so already,
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
all right, make sure I'm off mute. All right, I'm off mute. The Florida Supreme Court explained that the statute applies when a writing or recorded statement itself is introduced, that its purpose is to prevent a misleading impression created by presenting only part of the writing. Found case law in the Supreme Court to back up the redaction assertions. See Knock versus State. See Lazarle versus State. Accordingly, if plaintiff introduces the redacted account history, defendants may seek disclosure contemporaneous considerations of an omitted portion upon demonstrating that the portion is necessary in fairness to understand the exhibit actually offered. Defendants recognize that an investor account number, depending upon what the field actually represents, could contain information that should not appear in an unrestricted public filing. Florida Rule of General Practice and Judicial Administration 2.425. Come on, man. Come on, we get court is not just file, respond, challenge chain of assignment, challenge endorsement, challenge a note, challenge this, that's it. Now we enter the Florida Rule of General Practice and Judicial Administration. 2.425 requires specified sensitive financial account information to be minimized in court filings, and Rule 2420 provides mechanisms for protecting confidential judicial records. Defendants, therefore, do not request public disclosure of any information protected by those rules. If a legitimate confidentiality concern applies, the court may permit an appropriately redacted public copy while requiring an unredacted copy for counsel's review, in-camera inspection, or another procedure the court deems appropriate. So there's other ways they can show us. Accordingly, before plaintiff's redacted account history is admitted as substantive evidence of the amount due, defendants request that plaintiff be required to identify on the record the nature and basis of each material redaction, established through its sponsoring witness that the redacted portions do not conceal information necessary to authenticate the exhibit or materially impair the court's ability to evaluate its source, the identity of the account for which the records are maintained, its interpretation, or its trustworthiness. And 3, to the extent any omitted portion is necessary for a fair understanding of the document and ought in fairness to be considered contemporaneously under section 9108 Florida statutes. Provide that portion in a manner consistent with Florida rules of general practice and judicial administration 2.420, 2.425, or submit it for an in-camera review if the court deems such protection appropriate. The absence of credit, reversals, or adjustment entries cannot establish their non-occurrence without the foundations required by section 98037. Plaintiff offers its account history as evidence of the corporate advance balance included in the amount due. As reiterated earlier, the account history contains 105 entries characterized as corporate advances, but as produced, reflects no corresponding credit, reversal, repayment, or downward adjustment to those advances. Defendants do not ask the court to infer that the absence that a reimbursement or credit necessarily occurred, nor do defendants contend that payment by an insurer, investor, or third party automatically reduces the borrower's contractual indebtedness. And this is where 99.99 pro se litigants fail, right here. Thinking that you got paid by investors, thinking you got paid by, most people argue securitization like this. Defendant cannot prove harm because defendants got paid when they transfer the note to the investors. So since they got paid, they can't prove actual harm. Actually, I read that word for word last night in someone's arguments. That's the same 2008 to 2012 mortgage arguments. When you hear about mortgage defenses in these spaces, you're not going to read shit like this. You're not going to hear or read things like this. What you're going to read is the 2008 and 2012 version of mortgage defenses. And when the courts have long shut those doors. The narrow evidentiary issue is whether plaintiff may rely upon the absence of such entries as substantive proof that no offsetting credit, recovery, reversal, or adjustment affecting the amount due, the claimed amount due occurred. Section 98037 Florida statutes permits evidence of the absence of an entry in records of regularly conducted activity to prove the non-occurrence or non-existence of a matter only where the matter was of a kind of which a memorandum, report, record, or data compilation was regularly made or preserved. Subject to the statute's trustworthiness limitations. See Garcia v. State, 1990. Accordingly, authentication of the account history under sections 98036 does not, standing alone, establish that every credit, recovery, repayment, reversal, or adjustment reflecting the recoverable corporate advance balance necessarily would appear in that particular report. If plaintiff seeks to establish the completeness of the claim advance balance by relying upon the absence of such entries, its sponsoring witness should first establish that such matters, when they affect the amount recoverable for the borrower, are of a kind regularly recorded and preserved in the account history or other records upon which plaintiff relies. Defendants therefore request that plaintiff not be permitted to use the absence of a credit, reversal, repayment, recovery, or adjustment entry as substantive proof that no such event affecting the amount due occurred unless the predicate required by section 98037 is first established. If you don't really understand all the single rules that apply to your case, that's why I don't like this vague term, read the court rules. Y'all read, no. There may be 15 set of court rules that applies to this section of the case. There may be 7 different set of court rules that apply. So when you say read the court rules, like when you just start reading from the top, Like, you first, you got to read it. Then every courtroom you read, you got to understand how it's interpreted. You could just read the court rule all day, but the courts are interpreted a certain way. How you gonna know how the court's interpreted? So I don't tell people just read a court rule. I tell my group something different. Because reading, I mean, courts and rules are too nuanced to read. You see all these different sections I got to break down and narrow the point and narrow. No, we do admit, nope, they don't got to do this up, but they got to do this. They can't do this, but they got to do. See how nuanced this is? You can't just read. It don't work like that. This request does not shift plaintiff's evidentiary burden or require plaintiff to disprove the existence of identified reimbursements. It simply requires the statutory foundation before the absence of a business record entry is given evidentiary significance. Now, this is a very tricky one here. Ground 5, the source of pretrial transition service and data should be established if plaintiff relies upon integrated predecessors' records. Plaintiff's account history identifies a loan setup date of August 30 of 2022. Loan Depot Inc. in its 2022 Form 10-K states on February 1st, it completed the transfer of service and operations from Sinlar FBS, moving forward as Sinlar, and brought the servicing of its mortgages servicing rights in-house. The same filing states that as of December 31st, 2022, Sinlar continued to service a portion of the company's mortgage servicing rights portfolio. Defendants do not contend that this enterprise-level disclosure establishes that Sinlar serviced the subject loan, and defendants ask the court to draw no such inference. Its narrow relevance is that the reported August 30th, 2022 loan setup date preceded completion of the company's transfer of servicing operations in-house. If plaintiff relies upon entries originated during that period to establish the amount due, the source of those entries bears upon the foundation applicable to the account history. Florida law does not require plaintiff, sponsor, and witness to have created the records, worked for a predecessor servicer, personally participated in boarding processing, or explained the internal operation of plaintiff's software. Records received from another business may become the receiving business's own records when they are integrated and relied upon in the ordinary course of business, provided the requirements of Section 8036 are established and the circumstances sufficiently establish their reliability. See Bank of New York versus Callaway, Ocean Loan Servicer versus Gunderson. Conversely, where the record fails to establish whether predecessor servicer information was reviewed, checked, verified, or integrated into the current servicer's records, the required foundation may be deficient, meaning they never mentioned it. Accordingly, defendants request a narrow ruling. If plaintiff established that the material entries upon which it relies were generated and maintained within plaintiff's own record-keeping systems under its regular business practice, the ground is satisfied. If any material portion of the account history originated with Sinlar or another servicer and was later incorporated into plaintiff's records, plaintiff should identify that circumstance and establish the business record foundation applicable to the incorporated data, including the ordinary procedures by which such information was accepted, checked, integrated, and relied upon. You see how we just making it more for them to do? Just piling it on more. Because in the beginning, Remember, I already told the judge what really happened. The loan was from August 30th, 2022. On February 1st, it completed the transfer of service and operations from Cenlar and brought the servicing of its mortgage servicing rights in-house. And February 1st, 2023, the loan took place August 30th, 2022. See what I'm saying? So according to the loan, the date, it was under the Cenlar. Then it switched to in-house. So now that I know that, you didn't establish the foundation for the integration of prior business records. So now I'm going to make you establish it. 4 years later, now they got to go back and do all that paperwork to establish it, making it harder for them. Because they didn't start off in-house. They start off with Cenlar. Now they're in-house. See? But it's not even just that. It's, are you even looking for things like that? How nuancey that is? Oh, you started off with another service platform. Cenlar, now you're in-house. There's business integration rules right there. You never brought it up not one time. Now we're going to make it an issue. Materially revised judgment figures first disclosed after the governing pretrial deadline should be subject to the court's pretrial order and applicable disclosure. Defendants do not ask the court to freeze plaintiff's amount due calculation as of June 4, 2026. Interest and other properly recoverable amounts may continue to accrue, and an updated calculation is not objectable merely because it bears a later date. The concern is materially different. Introduction shortly before trial of a materially revised judgment figure, a previously undisclosed category of recovery, or supporting records that defendants have not had a reasonable opportunity to examine. And they did that shit then there a few days before trial last time, which is why I had to wing the last hearing by hand. I had to run the numbers in real time because they did it so much. And all those numbers, I didn't have time to break down every penny. So I just had to take their numbers and run the numbers in real time with a pen and pad, pen and notebook paper. Now, I'm saying, hey, Your Honor, they did this shit last time. Don't wait 2 days before to try to slide it on there. Plaintiff's reservation of a right to supplement exhibits list does not displace deadlines established by the court's governing pretrial or case management orders. Florida's current civil procedure framework requires such deadlines to be enforced. See Cresselis versus Resentino. And to the extent any revised calculation or supporting material supplements or corrects a discovery response governed by Florida Rules Civil Procedure 1.280G. See how many different rules and procedures I cited throughout this? With case law and the facts to support it. Why does everybody think that's something you could just do in one setting? Y'all understand how nuanced court can get. And that's not, it's because people always want to hear the ribbon in the sky for our love version. Let's all hold hands and come together and kumbaya. And we're trying to beat the system. And you can do this. Yep. You can do it. Yep. And you can win. All you got to do is just do this. Just do that and say that. And you can win. And you can beat them. You can do it. You can do it all night long. Oh, okay. So, hey, have you done that with have you done that with your own mortgage? Oh, no, I paid my mortgage. Then what the fuck are you babbling about for 2 hours? You paid your mortgage, but you're telling people that man, if you don't get the hell out of here. If you don't get the hell out of here. Oh, it's not that big deal to me. I pay my bills. Then that's what you really do in real life. You pay your bills. Remember, many teachers are not paying their bills with the methods that they're selling you to pay yours with. I say this time and time again. You pay them real money. They give you an alternative method to pay your bills. while they take your real money and go pay their bills. If y'all think these teachers are discharging their bills every month with the stuff they're selling you, you are hearing what you want to hear. You want to believe it's true. I'm sorry. I have to pop that bubble. It's not true. All of them are paying their bills with real money. None of them are paying the bills with the methods that they're selling y'all. Sorry. 98% is all about making money off a popular process. Y'all be acting like it's really going to work. Some of y'all has spent more money with these gurus than what the original debt was even worth. Some of y'all, all this money y'all spent with these gurus, y'all could have paid y'all bill and got y'all count off the green and lived peacefully. It is not uncommon in this space for people to pay more in gurus than with the fucking bill. They owe a bill, they owe $1,000. They rather pay $2,500 to figure out a way of not to pay that $1,000. Do you not understand how that sounds? They rather pay you $2,500 just to find an alternative way to cover that $1,000 debt. Florida Rule Civil Procedure 1.280G, that rule requires supplementation or correction in a timely manner when a prior response has become materially incomplete or incorrect and the additional information has not otherwise been made known to the other opposing party. Rule 1.380D provides that when information required to be disclosed or supplemented under Rule 1.280G is not timely provided, the party may not use that information to supply evidence at trial unless the failure was substantially justified or harmless. Florida Rule 1.230D. Chrysalis confirms that this standard operates independently of the broader Benger analysis applicable in other circumstances. See how I got to take these two cases and find the different analysis? Accordingly, if plaintiff seeks to introduce materially revised judgment figures, a new component of his claim recovery, or supporting records not timely disclosed as required by the governing pretrial order, applicable discovery rules, defendants request that the court enforce those requirements before the material is received in evidence. If the court permits the late disclosed material, defendants alternatively request a reasonable opportunity to review the revised calculation and its supporting records and to assert the same foundation, trustworthiness, completeness, and hearsay objections addressed above without consuming the limited trial period. Wherefore, defendants respectfully request that this court enter an order granting the evidentiary and pretrial relief set forth in Section 1 of this motion, together with such further relief as the court deems just and proper. You notice I didn't ask, hey, Your Honor, you notice I didn't ask and say, hey, Your Honor, I want this case to be eliminated. Your Honor, dismiss the case right now. Let me tell you something about people in these spaces. Many people treat court as an extension of the debt elimination process. They don't understand how court can drag out. They don't understand all the different elements, and they don't understand your first thing is, I want to beat the case and keep the house and keep everything and keep. Don't pay, but keep. You're asking for results that less than 1% of pro se litigants are going to sustain consistently throughout their lives of court. You're asking for it, and you're hoping, and teachers are guaranteeing you things that nobody can. So the pro se defendants filed this motion. Here's a summary of it. Filed this motion in advance, but it wasn't filed, of the non-jury trial set for September 1st, 2026, and a foreclosure action brought by Loan Depot. The motion seeks procedural rulings to ensure compliance with Florida rules evidence regarding the admission of plaintiff service and records and judgment figures, aiming to prevent foundational disputes during the limited 3-hour trial. Key relief requested. The defendant requests 4 specific rulings. Foundation for business records. That plaintiff supplemental exhibit 5 and account history not be admitted into evidence unless the plaintiff established the proper predicate under 9803(6) Florida statutes, affording the defendants an opportunity to raise objections regarding trustworthiness. Most people would say, hey, they violate the statute, Your Honor, so let it go. Block it. You always look to the most extreme of the extraordinary remedies instead of just chipping away at it. Make them do more to prove your case. Make them do more. They're the defendants here. We don't have to overstep. But it's not uncommon in pro se spaces where the defendants want to do the work of the plaintiff. Like you want to do too much. As Lawful Living has heard me say, as the defendant, your job is not to prove their case. They have to prove the case. Your job is to point out when they have not satisfied the statutory elements to prove their case. Second one, hearsay within business records that third-party charges, invoice, assessments incorporated into the corporate advantage balance not be admitted for the truth of the matter asserted unless they satisfy the multi-level hearsay requirements, Section 9805 and 9803(6). Unredacted records that the plaintiff not be permitted to rely on redacted versions of supplemental exhibit 5 or account histories that conceal material information, etc., etc. Timely discover and all that. This motion highlights material, unreconciled difference among 4 separate accounting records produced by plaintiff regarding the claimed corporate advances. March 16th and May 13th, and you already heard the numbers. Governing evidentiary standards, trustworthiness proviso, while acknowledging the Florida Supreme Court's ruling in Jackson regarding foundational witness requirements. Defendants emphasize that 9803(6) explicitly excludes records if the source of information or circumstances show a lack of trustworthiness. The unexplained accounting discrepancy serves as the basis for this trustworthiness challenges. Double hearsay. Citing 9805 Florida statutes, the defendants argue that the admissibility of a primary business record does not automatically extend to out-of-court statements or third-party charges. Y'all get ready. Embedded within it. Each layer of hearsay must independently meet an exception. Absence of entries. Citing 98037 Florida statute, the motion argues that the absence of a credit or adjustment in account history cannot be used as proof that no such event occurred unless foundational criteria for records of regularly conducted activity are met. Oh, yeah. Y'all, you got to understand one thing about court. To be honest with you, is this motion pretty good for pro se? Yes, for pro se motion, this is exceptionally well drafted and legally sound. It punches well above the weight of typical self-represented filings. Laser focused scope. Instead of trying to argue the merits of the entire foreclosure defense overall all over again, it targets a very specific practical bottleneck, admissibility of figures and ledgers. Judges appreciate this because it saves court time during a tight 3-hour trial. Prior legal authority. It correctly relies and cites controlling Florida law, Florida Evidence Codes 98036 for business records and 805 for double hearsay, without misinterpreting the boundaries set by Jackson Household Finance Corp. Without misinterpreting the boundaries set by Jackson versus Household Finance Corp. Targeted concession. A common trap for pro se litigants is fighting losing battles, like trying to force banks to explain complex software source code. By explicitly conceding that you aren't challenging the software mechanics under Jackson, you show the judge you understand the law, which instantly builds credibility.
You're rocking with the best. You're rocking with the best. You're rocking with the best. You're rocking with the best.
Concrete evidence of unreliability. Rather than making vague claims that the bank is wrong, Section 2 lays out math with specific document dates, figures, and an irreconcilable $989.59 gap over the same exact period. That's what you get when you get the ledger.
They studying the source now. Supreme Elite. New Empire talk.
That's what happens. You get the numbers from the records. Minor points to double check before time. Format and local Rosolia certifications, service and margins, and font size strictly comply. Of course, that's oh yeah, there's some little minor typos that when I go back and do the find, I ain't edit. I just when I finish typing it, I didn't go back and check. And that's why you'll see me like say like to advanced balance, all that minor. That's fine and correcting the font and the typos and putting the commas. I haven't done that part yet. Exhibits attached. Make sure the 4 conflicting records mentioned in Section 2 are actually attached as exhibits or properly. Of course, there's going to be the exhibits. I'm using their, remember, with the ledger, the hidden figures, we use their exhibits as our evidence. So when they file their exhibits, that's what we use as the evidence. Yeah. Yeah, I take their evidence against these people here in Florida. I'm taking their evidence, and that's our evidence now. This is why they haven't filed nothing in months. They stopped filing. They have not filed nothing. I'm trying to get them to engage. They just won't engage with me. They won't engage. She told me that before we connected, they was responding to everything the gurus had to put on the records. Motions to strike, motions to strike, motions to this, motions to deny, motions to strike, order to strike, order, motion to strike granted, motion to strike granted, strike, strike, strike. And ever since, was it February, March? Silence. Yeah. Silence. I'm trying to get them to respond. They won't do it. They won't take the bait. When evaluated against standard legal work product, this motion ranks in the top tier of motions drafted by pro se litigants and comfortably holds its own against filings produced by mid-level civil litigation attorneys. Among pro se filings, top 1%. The vast majority of pro se legal motions fall into 2 unproductive traps: emotional rants about unfairness or heavy-handed legal garbage copied from internet templates that misstate local or state law. This motion is an outlier. It demonstrates a precise clinical understanding of trial mechanics. Remember, tax layer, what experience? Oh, no, new culture. You never sat through an actual pre-trial motion when your lawyers is battling out over evidence before trial. Oh no, you didn't sit through 3 hours jury selections and going over jury instructions with your attorney. No, you didn't get a laundry list of rules to study from your attorney. No, you didn't actually sit through it. You didn't actually have to argue your own motion in front of a federal judge. No. You've never done that. No. You didn't file a motion to get your case held in abeyance in federal court for 5 years. You wasn't a hair of beating the government, even though I don't like to steal laws. But you wasn't a hair on beating the government on an argument that the 2 cases that were before you didn't raise, that put the Fourth Circuit in a pickle with a free 70,000 inmates. Nah, they couldn't, they had to come up with a way to deny you after 5 years of your case being on appeal. 5 years. Nah, you don't understand, court. You ain't spank a multi-billion-dollar corporation this year. One of the corporate giants. You ain't make them tap out. You ain't make Westlake abandon their trial on the day of trial, drop the whole case. Nah. You ain't do that this year. Nah. You don't know what the satisfaction of lien looks like, new coach. Nah. You ain't ever do that. You ain't get a credit union in a non-judicial state to cancel 2 foreclosure sales. Nah, you don't got evidence of that. You're lying. You ain't got no title to your shit from the settlement. Account 0. You ain't do it like that. You're lying, new culture. You don't have it because we don't see it like that. If we don't got it, what makes you think you got it? What makes you so special? What makes you so different? You don't have it. You're capping. I know. You don't spank credit cards with just a letter and then writing you telling you don't owe anymore. You're lying. Everybody got to go to court. Everybody got to do the FDCPA. Everybody got to fight. Everybody got to wait till they get sued. How you getting yours with just a letter to them? We can't apply your teachings to outside of just court. Yo, you ain't running credit score up 146 points just by using set you knowledge and just sending a letter to the credit bureau. And you don't even how you do that? You don't even teach credit report. You don't run credit scores up just by the accounting hitting on the accountant to a credit reporting agency. Get out of here. Inside of 10 days, get out of here. Changing the remarks, get out of here. No, you don't do none of that. Nobody in your group wins. Nobody. You lying when you said one person beat 4 cases this year from your group. You're lying. It didn't happen. Show us. Right. Of course. Right. It's what they want to believe. They have to believe it. Because if they believe anything else, which everything I said is actual, factual, everything I said is documented. And you don't really have to look far. You don't really have to look far. Because if we believe that, then that means my teacher's wrong. And I like my teacher. I look at my teacher as the end all be all. It's us against him. I got a title too. My clients get that all the time. What's on the page? Talk posts. Talk. What do you mean? You don't deal in consumer law. What are you talking about? This whole space is about consumer law. What do you mean? 5 lenses of the contract. What are you talking about? Contract being looked at 5 different ways. What do you mean? It's the consumer way. That's it. Consumer laws. What do you mean? Some 5 lenses of the contract. What are you talking about? All that technical shit, corporation. We don't want to hear that shit. Consumer laws. Consumer. You got lucky for credit acceptance. You got lucky. Anybody could do that. Anybody could beat credit acceptance. Anybody can. They beating them all the time. Shit, there's plenty of people who credit acceptance wiped out the balance, walked away from 20,000 and then gave you the vehicle free and clean. You don't got to pay for it no more. It's yours. You own it. That happens all the time online. Matter of fact, it happened yesterday. Shit, I just seen about 50 people beating credit acceptance the same way. What? Oh, you think you special because you filed because you was the plaintiff and current? What makes you think you're so special? Because you do? Everybody do that all the time. Everybody files while they plaintiff and the current. That's the name of the game. We all doing. Everybody doing the same thing. Everybody's winning. What are you talking about? So you called the lawyer, and the lawyer said you played a big role in it. So what? Everybody else got phone calls with lawyers. But you ain't doing nothing special. I can call you. I can show you right now. It's 15 people with a lawyer saying the same thing you're saying. I know. That's what they want. They have to. That's what they tell themselves. But they know the opposite. They know it's not happening like that. They know. I'm on pro safe. Nah, for no, this is the stuff that they really be telling themselves. No, they really. This is the stuff that they really be telling themselves. Like they really have to tell themselves this. This is the stuff that they really tell themselves when they look at my page, when they hear me talk. Like they really have to find a way to discredit it. They have to find a way. Want to know why? It's because it's not what they're used to hearing. It's not what they're used to hearing. I'm on pro se filings, top 1%. The vast majority of pro se legal motions fall into unproductive traps. Emotional rants about unfairness or heavy-handed legal garbage copied from internet templates that misstate local or state law. This motion is an outlier. It demonstrates a precise clinical understanding of trial mechanics, rules of evidence, and procedural boundaries. I'm on practicing attorney, solid, competent, above average. If a junior associate or contract attorney submitted this motion to a senior partner, it will be met with approval. If a junior associate or contract attorney submitted this motion to a senior partner, it will be met with approval. You wasn't offered a job at a paralegal fresh out the feds based on your arguments you raised in your own federal case by a law firm in Newport News. You wasn't offered an entry-level salary of $52,000 that you turned down because you was moving back up north. No, the lawyers, they didn't offer you a job as a paralegal. No, that didn't happen. That they was going to work with you to get your qualifications and do all of that. They didn't offer you that back in 2020. Nah, they didn't. You're lying. It can't be true. New culture, you got to stop the cap. You be doing too much capping. You know damn well that's not an ex-SEC attorney that stamps your work. 27 years at the SEC. He hasn't stamped your work.
According to your conversation with your friend, the attorney, what we go over in group is right in line with the legal standards and the professionalism on how it has to look and what you need to know when you attack these people.
The words that he used was, "You're going about it standard operating procedures."
Standard operating procedures. That lawyer, that attorney don't know nothing. So he don't know nothing. It's just the SEC. SEC ain't nobody spectacular. Shit, I can have the lawyer say the same thing about me. You're not saying nothing. You're not doing nothing. You ain't nobody, new culture. You ain't nobody at all. You are not nobody. Talking about you had law firms reached out to you when you filed your lawsuit. They ain't reach out to you. They wasn't on the phone with you. They didn't respond to your emails. They didn't send you a letter congratulating you. What a hell of an argument. You need to stop what you're doing. The paper trail. You need to stop what you're doing. You don't be documenting your stuff. You ain't document your credit acceptance case. You ain't do none of that. You need to stop.
Shout out to the whole Untouchable Empire, man. Man, shout out to the paper trail.
The reason that you're not able to access the information through our customer portal is because
you got to stop lying. You didn't call credit acceptance after you sent the documents before you filed the lawsuit. You got to stop lying. You ain't got no, you don't be recording these phone calls. You don't be posting this stuff. You don't got phone calls where they've been admitting to you over the phone for years that you're right. No, you don't. Well, just because I don't see it, that don't mean it ain't true. Well, it's on this new culture page. It's been up there for a while. Everybody said, I don't care. I don't want to see it. I don't want to see it then. If it's there, then I don't want to see it.
Of the email that we or letter that the reason that you're not able to access the information through our customer portal is because of the email that we or letter that we received from you. That was actually escalated to our compliance team. So whenever we have an issue or we're investigating something, we place everything on hold.
Your documents is not that powerful that they escalated to compliance, put your account in a hole, and don't ever attempt to collect from you ever again until you settle. Yeah, that happens every day. What are you talking about? Everybody gets that. Everybody gets treated like that. Of course they do. And there you go with this damn attorney again. He's not talking about you, New Culture. He's not talking about you. Stop lying.
Whoever you got to doing this, he says, he must be on his game. He said, because he said, most attorneys that's got 10, 15 years of practice, he said, don't even understand this language. He said, they don't know nothing about this realm, this world. It's a foreign world. So
you got to stop lying, New Culture. If a junior associate or contract attorney submitted this motion to a senior partner, it will be met with approval. While seasoned foreclosure defense specialists routinely deploy these exact arguments, many routinely churn out lazy, cut and pasted boilerplate. This document avoids boilerplate by executing a targeted mathematical cross-examination of plaintiff's internal record. When you talk about the ledger and get your own account audit, you just capping. You just trying to make money. You don't know how to run the numbers. You don't know how to run the numbers. You don't know how to run the numbers for real. You don't analyze each number. Stop lying. New Culture, you don't know how to run numbers. Keep talking this accounting stuff. You don't know how to read a balance sheet. What are you talking about? He has classes where he actually broke down every component of a balance sheet and broke it all down. What are you talking? And I don't care. I don't care. Well,
and both times. So that wouldn't be in your records because you didn't pay.
What, according to insurance? Is there any evidence of the insurance being paid in? That they took out the insurance?
Okay.
There's no requirement to establish insurance being taken out.
Is that what we're referring to as corporate advances?
1 second.
Is that what we're referring to as corporate advances, or is that something else?
Gotcha, bitch.
Correct.
I believe so.
You don't have You're not with your clients right there in court. You don't know how to quarterback a hearing from thousands of miles away on the phone. Ah, you be lying. You ain't got experience of being in a courtroom where all you got to do is just hear what's going on. You don't got experience of being in a courtroom. You don't know what it's like, the nuances. You haven't spent 22 years in the inside courtrooms, in and out of courts, motions, trials. You haven't. You just got lucky on this hearing. You wasn't relaying 95% of what she's saying to her. You wasn't basically talking through her to the judge. Nah, you wasn't. Well, he has a video he's playing right now. That's not him. I don't see him on the video. You can literally, you find it, you can hear his voice in the background. He got a very distinct voice. He has a phone call where he talked to her afterwards. That could have been somebody else. Yeah, of course. And the excuses will never stop. So when you try to make people happy a bit, you don't do it. It don't matter. You can't try to get through people who has no intent on understanding you. They will look at the reality in their face and still deny what they see. Meanwhile, hoping for every single failure. But they haven't realized is me failing doesn't make you a winner. My failures still don't make you a winner. So if you were losing before me, pretty much you're still the same loser.
Okay, I just pulled it up. Okay, so you're saying that the 4,666 and 26 cents were added? Because then that still doesn't even add up.
Gotcha, bitch.
I'm tending to agree. I'm tending to agree. I'm tending to agree.
You're rocking with the best.
They're studying the source now. Supreme Elite.
If you take your payoff amount, you have 4,000 and 10,000. It's going to be more than your 432.
And then, sorry, Judge, I know you mentioned one thing at a time, but again, that document does not have the loan
set aside and the
monthly premiums.
Well,
I got you to my ears, so whatever you want me to say, I can say it. I got you low too.
That's not her talking to you, new culture. She's not talking to you on the phone. That's not you. Stop lying to the people.
I'm trying to get you close enough to hear it, but sometimes you get loud. I think they hear it.
New culture, you don't get loud. She's not talking about your characteristics. You don't get loud. You talk like this all day. So that must be somebody else.
does it have to?
So for the $24,870.65 payment into escrow.
These fees come from any of my monthly
property, which is generally more expensive than if you took it out, but it's only because you're in default that they have to take it out. So that wouldn't be in your records because you didn't pay it. That's why the bank had to pay it.
Nah, that's not you in the background lining up the question. That causes the judge to throw the ball back in their court after she's obviously answering the questions for them.
Is there any evidence of the insurance being paid in? That they took out the insurance?
Nah, new culture, that wasn't your question. That wasn't your question at all. You know it wasn't. You could tell it wasn't her question because she didn't even get it right. I had to correct it. Man, anybody could have asked that question. They'd have been silent. What do you mean?
Okay.
There's no requirement to establish insurance being taken out, only that the payments have been expended, which is what the payment history that's been admitted as Plaintiff's Exhibit 4.
There's no requirement to show that the insurance has been taken out. only requirement to show that payments have been expended. Isn't that asked backwards? Ain't actually a simple question, y'all. Anybody has insurance right now? Auto insurance or whatever? In order for you to, before you pay your monthly premiums, didn't you have to go call Geico and get on insurance or homeowners? Don't the insurance contract that you take out first comes before your premiums? Right. What comes first, your insurance premiums or your contract? What comes first? That's just normal reality. What comes first? Did they just pop up and say, hey, you owe $433 this month for premiums without a contract? Without a contract? So she said there's no requirement to show that a contract been made, take it out, but only that it's been expended. Y'all know that don't even make sense.
Been entered into evidence.
Oh, really?
I'm just trying to double check here on the attorney fees, Your Honor.
Yeah, the reason why you're double checking. Oh, here's another thing, new coach. You ain't gonna be able to figure out the reason why you're double checking, because it shows your attorney's fees right there on the screen, but you got the same amount built inside of corporate advances. That's what you're looking at. You're looking at the same thing I'm looking at. You're looking at the same thing that was a part of that motion. You're looking at the same thing that's part of the exhibits. You got $3,900 some as separate attorney's fees, but you got the same amount built inside the corporate advances. That's what you're looking at. I know. That's what you're looking at. That's what you're looking at. And look at this. If the total sum with interest, and rate described in paragraph 1, the highest bidder for cash. Look at this right here. See, they exposed too much on this screen because I took the wordings on this screen. Plaintiff shall advance all subsequent costs of this action and shall be reimbursed from the loan, something down at 4. Proposed final judgment. See that? Silence. Silence.
And then I want to know, how did our monthly payments not go towards the monthly premiums?
Nah, new coach, you didn't, that wasn't you right there.
Again, like, I understand what you're showing me here, but there's not really that much details.
Nah, you ain't get her on point for this. She was with the sovereign citizen gurus, didn't know what to do. 90 days with me, she's confident as ever. Nah, that's not your influence. Nah. You're new coach, you're just lying. That's not even your client. This is someone else. You just copied the video. Somebody sent you the video of somebody. They did this on their own. And more silence. And more silence. And more silence. And more silence.
Counsel, I think this is becoming too complicated to be doing this on Zoom without having the records here. I think it needs to be done in person.
Okay.
And let's go ahead and just refer it back to the assigned judge so it can be done in person.
So what? They didn't get the judgment that day. So what? That don't mean nothing. So what? So what, new culture?
Exhibit 5.
Here's Exhibit 5, which is the judgment figures.
All the other documents have the header.
This is an exhibit list that was filed on 5/13. Counsel.
No, Your Honor.
Okay.
So I'm not sure if she's reading off of this exhibit or the previously filed exhibit from 5/13.
So, are you referring to the updated exhibit that was filed on June 4th?
Checking now.
Of 422 council, it's showing a payoff of while she's checking council, it's showing a payoff of 422 516 86.
Yeah, they did. They made a new one over in
So how do we get the extra roughly 10,000 on that?
So like they're really trying.
That's the same thing that I said, Your Honor. How did you get the extra? So what? You and the judge is on the same page here. That anybody can go to court and them and the judge be on the same page. You're making the same arguments, that same thing the judge saw. You ain't doing nothing spectacular. It's normal. Everybody goes to court and does this.
Under the math over
This summary does not include the attorney's fees and costs that were expended.
Okay, so we would take that payoff number and then add your affidavit of attorney fees and costs.
Correct.
She didn't even say that correct with confidence.
I believe so. Because then that still doesn't even add up.
Gotcha, bitch. Correct. That was the outstanding balance on the mortgage. Correct.
Let me find it.
All right, and the interest the lender had to pay.
The firm expended down these
Recently. The corporate advance is $16,955.90. I did the math.
Same thing we rehearsed. Now, you don't got your notepad on the counter over there writing notes saying, do the math. I got a different number. It's not adding up. Throw the script away. We right here. Found it. Right here. We stand right here. The number's not adding up. They can't foreclose unless the numbers add up. Right here. Throw the script as far as you can throw it. Right now. Throw it outside. Ball it up. Put it in a tiki can. We stand right here. Damn that script. Right here. We gonna wing it off the top of our head for the rest of the hearing.
Math already. These numbers are not matching up. So what would be, if you're saying that that's the attorney fee, so what is that $16,955.90?
Yep. The ledger, the hidden figures, get your report today.
If you already had your attorney fees over here on this document that you're showing me.
And that's what I caught her right there, told her. They double dipping. They got their attorney's fees already there. Now they got it hidden over there inside there. Let's talk about that. Gotcha, bitch.
I'm not sure which part of the record she's.
It's in your exhibit list.
You know what page of the exhibit list?
The last one, page 33.
Exhibit 5.
Exhibit 5.
Here's exhibit 5, which is the judgment figures.
She don't even know.
And then while we're adding to that too, another thing that I wanted to mention is why. Crap, where is it?
This exhibit list that was filed on 5.
Judgment figures that was filed on June 4th.
Okay.
It was a supplement to update the judgment figures and the breakdown of those figures more succinctly. So it was filed as a supplemental exhibit on June 4th.
Okay.
So I'm not sure if she's reading off of this exhibit or
to the updated exhibit that 516, extra roughly 10,000 on that.
So like they're really trying to do the math over here.
this summary does not include the attorney's fees and costs that were expended.
Okay, so we would take that payoff number and then add your affidavit of attorney fees and costs.
Correct.
I believe so. Because then that still doesn't even add up.
Gotcha, bitch.
I'm tending to agree. I'm beginning to agree with the defense that there's some confusion. I'm beginning to agree with the defense that there's some confusion. I'm beginning to agree with the defense that there's some confusion.
You don't know what you talk about, new culture. You don't do this shit in real life. You don't do this shit in real life. You don't do this in real life. You don't do this in real life. It's just on. You just like the rest of them, just talking online to try to win try to make a couple dollars. You just like the rest. They just talking online. Everybody else, I done got took to the bank 5,000 times. I don't give a damn. I ain't trying. Nobody know what they doing. I don't care because I got scammed because my old pride and ego and my greed got the best of me. So since it didn't work for me, then nobody knows what they're doing. So I'm just gonna hang around the comments. I'm gonna listen to what you got to say. But I ain't about to spend no money on no shit now because I got scammed before, and I don't like the fact that I got scammed. I don't get that $350 million that thing told me I was gonna get. I know. I know. Why is scored so highly? The Lorley markers. Proper handling of controlled precedents. Many attorneys and pro se litigants mistakenly tried to fight the Florida Supreme Court's ruling in Jackson, wasting the court time by demanding the software mechanics be explained. This motion smartly concedes Jackson's baseline while weaponizes its lesser-sided companion principle, the trustworthiness proviso. Attorneys know that judges skim abstract legal theories but lean heavily on concrete numbers, highlighting a real unreconciled 989 discrepancy over the exact same period across two different internal documents moves the argument out of the realm of delay tactics into actual evidentiary unreliability. Double hearsay nuance, pinpointing third-party corporate advances like property preservation, tax, or legal fees embedded in the service ledgers is a sophisticated maneuver. Most practitioners treat a loan history as a monolithic block. This motion correctly forces the plaintiff to justify every underlying layer of hearsay. If you were to rank this in pro se spaces, does this motion set the standard? Yes, this motion doesn't just rank at the top, it sets the absolute gold standard for what a pro se litigant can achieve in civil litigation. If law school clinics or self-help legal centers wanted to put together an example for how a self-represented party should challenge banks' ledgers and corporate advances in the foreclosure actions, this document would be the blueprint. Sorry, y'all. It said a buzzword. It said a word that just triggered me. It just triggered me.
Came on reading numbers. They studying the source now. Supreme elite. New then he beat litigation. Now he like blueprint. Blue God, that's the real drip. Let it dry now. Thomas is the blueprint.
Strategic concession as a power move. Most pro se filings collapse because they argue everything at once, making them look unhinged to a judge. This motion explicitly concedes what it cannot win, software mechanics under Jackson's, to secure firm ground on what it can win, the trustworthiness proviso and double hearsay. That level of tactical restraint is rare, even among experienced litigators. Forensic precision. It doesn't just complain that the numbers are wrong. It lines up 4 separate filings side by side, exposing a specific 989.59 discrepancy over an identical time frame, and highlights that a 91.4% of corporate advances were piled on after the lawsuit started. That turns a legal argument into an undeniable math problem for the judge. I'm attending to agree with the defendants. There's some confusion. Anticipated trial bottlenecks. By framing the motion as a way to save the court's limited 3-hour trial time, it speaks directly to a judge's primary administrative priority, efficiency. You don't understand how courts work. You don't understand how judges want things to move fast and don't be tied up. You don't like submitting 5,000 pages before a trial is going to cause them to time. You don't understand judges want an efficiency thing to move on. No. You don't have enough experience in court to anticipate that, new culture. You don't have enough experience for that, the new culture. Judges are far more likely to entertain evidentiary objections when they are presented as a tool to prevent trial chaos rather than a delay tactic. You got to pro se, everything they do is a delay. That's a consensus. You're just trying to delay. No, Your Honor, we're not like the rest of the pro se. We're actually coming in as real litigants. We have a real issue here. We're not trying to delay. No caps. I got the message. I'm going to get back to you in a minute. It represents the absolute ceiling of self-effective representations. So what I'm saying all that to say this. Move away from the online theories. Join the new culture empire movement and join part of the new culture as we revolutionize the way pro se litigants, just like you and I, litigate our cases. Forget that BS that got out there. Join an empowerment movement. We are setting a movement. Join the movement. This is not me, follow me, do with me. This is a movement. A movement is not achieved by one person. A movement is not achieved by one person. If I had 50 people, 50 whose motions are all mirrored like baseline, this level and above, then you will start to see it sprinkle and sprinkle till real change has to start happening. They won't be able to railroad or deny anymore because you are not giving them every reason to do so. And it saves you on the back end. Because even if you ever have to go on appeal, you got ripe, valid appellate arguments already preserved. You got it already preserved. It's already preserved. So you're covering both ends. The days of you think you could just walk into court, file a document, and win, it's over. This is not a debt elimination extension. Want to join the movement? Send them email to thomaslegacy603@gmail.com. If you need documents reviewed, let me just review your shit. I don't even have to file it for you. Hey, this is some things that you probably need to tighten up. If you need your numbers ran, if you need the ledger, the hidden figures, the numbers ran, send the email. If you want your numbers ran from the record, whether it's a servicing, whether they respond to your QWR, whether you got your account statement, whether they filed judgment figures, this is a powerful tool to cause confusion in their collection efforts. And if you are current and a plaintiff, you still get the ledger because now it takes you to another stratosphere. Get the ledger. It's been tried, it's been tested, it's been proven, and you just saw the application of it in open live court. That's the standard universal. The amounts do have to be accurate. We apply the 5 lenses of the contract to prove that the numbers on the contract are not real. So if they're trying to collect on that, if you're making your monthly payments on time, it proves that you paying shit that wasn't even authorized to the contract. That causes real harm. When we add up all the amounts that they got you paying in full, then you got me paying $20,000 more. That's outside the scope of the true agreement. You know what? Don't listen to me. Don't listen to me, ladies and gentlemen. I'm just saying, just go ahead and do your thing, man. Go ahead and do your thing. Yeah, don't want to talk about that. Don't do the thing. Ali, I'm going to hit you up today, broski. I'll call you today. I need to get an update with you. Get the ledger, get the report. Some of you that's in court, you'll be able to take it from there. You'll know what to do. I'm pretty sure a lot of you will know what to do from there because it don't just come with the numbers. It comes with, according to your state rules, your state statutes, it comes with These are your legal causes of action. These are the court rules that govern. This is precedent that governs. This is how the specific facts apply to your case. Starting Monday, my weekly newsletters will be available through the Patreon. It will be available. The newsletter will be available. You get four newsletter a month for $25. It's going to be in its own separate tier. And you get your newsletters, your 4 newsletters a month, 1 newsletter a week, keep you updated on all currents, everything dealing with litigation, court, accounting. It keeps you updated. Those newsletters are powerful too, because it comes with all its sources. So you can go down and read the sources, read the professional law journals, law review. Now your research starts to head in a different direction. You're not just researching confirmation bias stuff. It starts to head in a different direction. All right, y'all. It's been real. My kids is waiting for me. I took up all my time, took up a lot of their